Hello, I'm Philip Sales. In this video I'm interviewing Michelle Dyson, a government lawyer. We're going to be talking about the role of officials in handling the passage of a bill through Parliament. Michelle, how does the process of actually creating an Act of Parliament differ from pre-legislative scrutiny?
Well, as we were saying, the pre-legislative scrutiny is about taking evidence from interested parties. Taking a bill through Parliament is different. I mean, it has lots of different stages, unless it's emergency legislation when they can all be sort of compressed into one day. But in principle, it has lots of different stages, and particularly the committee stage is really incredibly detailed. You go through each clause of the bill and there has to be a vote. I mean, it might be taken quickly, but there has to be a vote on whether that clause should stand as part of the bill, so it should be part of the bill. And members can put down amendments to the bill, including, I mean, the government might put down amendments if it's realised that it's got things wrong with the bill, but the opposition will put down amendments to probe the bill, and there'll be really detailed textual amendments, and for each one there'll be a debate on whether to sort of accept it or not.
Before one gets to the committee stage, what are the stages that a bill has to go through on its way to becoming an act?
Well, first of all, there'll be introduction, then there's second reading, then there's the committee stage, then there's report, then there's third reading. And
what happens briefly at each of those stages?
In principle, introduction is sort of a non-event. No one needs to be there. I think it just happens formally. Second reading will be set-piece debates on the floor of the House, which usually your Secretary of State would be at in the Commons. Obviously in the Lords it's different, assuming your Secretary of State is a minister in the Commons, it can't be in the Lords. Committee stages, as I've just described, very, very detailed. Report and third reading, which are run together in the Commons but not in the Lords, are sort of, again, set-piece speeches, although you can have amendments made at those stages as well.
So if one takes the second reading, what do officials have to do for that?
Well, draft a speech for your minister and provide lots and lots of briefing on the background of the bill, what the bill does. So this will be written briefing, what the bill does, questions and answers. This is trying to anticipate questions, issues that, you know, the difficult issues, we sort of call them elephant traps, you know, the ones that the minister needs to be warned about. So there'll be a lot of written briefing, and the minister would probably also want oral briefing, so the chance to discuss with officials how to handle it all.
And what is the minister's speech designed to achieve at the second reading stage?
I suppose to make the case for the bill, and this is an opportunity to get real, you know, to really bring the bill into the public domain, explain, say that how the government is taking forwards its manifesto commitment, sell the bill to the world at large, and you usually get quite a lot of press coverage of second reading.
And are officials in Parliament during the second reading?
Yeah, absolutely. You'll be sitting in the box and sort of.
Now, tell us about the box, because I've heard about this before.
Okay, the box. The box is physically in the chamber. So in the Commons, it's right at the back, sort of behind the Speaker in the corner. The Lords, it's slightly more sort of central. And in committee, where the committee, it just happens in a room, you'll be really quite close to sitting pretty much just behind your minister. You'll have your key officials in the box, and their role is to listen to the debate, and if questions are asked that the minister hasn't had briefing on, then their role is to scribble an answer, and it feels much like an exam, because one, you've got to write legibly, and two, you've got to do it as fast as you can. I mean, in some cases it will be your minister doesn't have to respond until the end of the debate, but in other cases, particularly in committee, your minister will really need to respond, if possible, on the spot. Otherwise, your minister may end up sort of saying, "Oh, I'll write to you afterwards," which is not.
Sounds a bit weak.
It sounds a bit weak. So it's better if they have an answer. But one of the difficulties of being in the box is actually getting your note to the minister, particularly in the Commons, where you're behind him. So you'll be waving your note around and hoping that somebody notices and passes it forwards to the minister. I mean, sometimes in, say, something like a second reading, or maybe later on, the minister might actually walk over to you and ask a question. But mostly you'll be briefing them with notes.
So the real work is done in the committee stage, is that right?
Yeah, I think that's right, yes.
And the committee stage addresses the process of amendment of the bill. How does someone put down an amendment?
That's a good question. I think that there's through some sort of parliamentary processes, through the House authorities, there's a means of putting them down. The difficulty for officials is that you often don't get the amendments until the night before the debate, and yet you've got to turn them around in terms of, well, first of all, analysing what they do, and then writing that up for the minister. So you need to do a note that explains the effect of the amendment, then a speaking note about whether to accept the amendment or whether to oppose it, and if so, what you can say about opposing it, and sort of questions and answers again to go with it. So that's a lot. You might have a large number of amendments. So it's all fairly frenetic, and you need pretty good IT systems as well to try and cope with the volume of material, and everything the policy officials write needs to be checked by the lawyers, and so it's
How many people will be involved in preparing answers on amendments?
Just depend. I mean, your key people will be your policy official and your lawyer, but it depends on how many policy officials are involved in. The amendments might come along in lots of different policy areas. So.
And are there different sorts of amendments that are put down?
Yeah, you might have ones that are very technical, sort of add a word in here and you're sort of slightly left wondering what the purpose is. Always difficult to write your note when you don't actually understand the purpose of the amendment. And then others will be obviously, you'll know that the bill is controversial in a particular respect, and you'll get another amendment which is clearly designed to lead to a vote on that issue.
And what happens after the debates? What do officials do then?
Well, if their ministers promise to write because they haven't had an answer at the stage, then they'll have to put up a draft letter. You'll certainly be scouring Hansard, which is the official record of Parliament, to see if any commitments have been made that you need to act on, like writing. If the committee stage might well have thrown up some technical problem with the bill, you might need to instruct Parliamentary Council to change that. And it might be that one bit of your bill is becoming impossibly controversial and is risking the whole bill, and therefore you might want to put options to your minister about how to deal with that, whether you want to drop it or what the best option, the best outcome is.
And do you need to go back to Cabinet to get clearance for amendments?
Not the really technical ones, but anything that amounts to a significant change of policy, yes.
And are there other parliamentary committees that scrutinise legislation?
Yes, you have two in particular. One is the Joint Committee on Human Rights, who will be looking at the human rights compatibility of every bill, and they will usually ask lots of questions of a department, which the department then has to put in a memorandum explaining why they consider this to be human rights, different bits of the bill to be human rights compatible. The other committee is the Delegated Powers, House of Lords Delegated Powers Committee, and what that committee is looking at is all the powers in the bill to do things by delegated legislation, i.e. by secondary legislation, because they're concerned because secondary legislation gets much less parliamentary scrutiny than primary legislation. So you might, in theory, just have very bare bones in your primary legislation and then do all the detail that Parliament's actually interested in your secondary legislation. So what the Delegated Powers Committee looks at, and the department has to provide a memorandum explaining why each power is justified, they'll look at whether it's justified to delegate the legislation downwards, and if so, what level of scrutiny that secondary legislation should have.
And do these committees provide reports?
They do, and again, as we were discussing with the pre-legislative scrutiny report, if they're very critical of you, you are well advised to either concede the point or you'll have to fight very hard to explain why you're not conceding the point.
How do bills finally come into force as law?
Well, first of all, you get royal assent, which will be at the end of the process, and then some bills will come into force automatically, So the bill will provide, this bill comes into force 2 months after royal assent. Usually there's a gap between royal assent and commencement to allow people to prepare. But probably more commonly, you'll have a power in the bill to enable the bill to be commenced, and often that's done in a staged way because you may need to make secondary legislation before the bill can be commenced. You may need guidance. There may be, often are, a sort of whole big sort of section of work that needs to be done and people who need to be engaged with before you can actually commence the bill.
And how long will it take before a commencement power is used?
I don't think there's really any answer to that, and you still have some legislation that hasn't been commenced on the statute book that that dates back for many years, and that may be because there was never enough money to commence new powers, or so it can vary. 2 months is, unless it's emergency legislation, unlikely to be less than 2 months, but it can go for a long time beyond that. But I suppose most legislation will be 1 or 2 years.
And then I suppose a process of implementation of the bill, once you've got a bill and you've made it into an Act of Parliament, the department must have to put into effect that Act.
Yeah, and that was really what I was talking about in terms of making the secondary legislation, talking to people on the ground who are going to have to operate it, say if that's the sort of bill it is, issuing guidance. All of that sort of thing is what we talk about as being implementation, and can be a really significant project in its own right.
And is it the same team of people that are involved in that, or does it get passed on to other people?
Depends. It can be the same team of people, and obviously there's advantage in that, but because the whole process is so long, sometimes it's difficult to keep people for that length of time. And I suppose if you are going to change team, then, or change, say, policy official or bill manager, then the royal assent is a sort of obvious cut-off point.
Michelle, thank you very much for talking to us about the official's role in the passage of legislation through Parliament.
Thank you.